Sedition was not an offence when the Indian Penal Code was drafted, Macaulay's document. It was only in 1871 that the section 124A was introduced to the Indian Penal Code. The subject was that to ensure that the legitimacy of the British government is not questioned. And with the kind of discussion that was happening those days, in fact, a few years later you had formation of Congress party, and you had great amount of legislation that's coming into picture. For example, the good number of British laws that existed were applied to Indian, this one more particularly relating to law related to business, law relating to criminality, or law related to properties. So this was something which they wanted to ensure that some legitimacy to the government be protected. So any dissent against the government was supposed to be silenced. I think therein they brought this particular law, introducing section 124A to the Indian Penal Code as against Her Majesty's government at that point of time. But what mattered most was that thereafter the extensive use of this particular law during the freedom movement. In fact, it started with the Bango Basi judgment in 1898. Thereafter, the major trial on sedition was that of Bal Gangadhar Tilak. In fact, it was a question of defiance. The defense became more and more pronounced as the freedom movement got its momentum, and in fact, it saw one of the greatest challenges to this particular law was in trial of Mahatma Gandhi. In fact, he said either you can have law or you can have sedition. Sedition and law can't go together, and that is the analogy that was presented by reference that was presented by Mahatma Gandhi. In fact, it goes to the extent of making a statement to the judge: if you want to follow law, punish me with the severest of the punishment because I am guilty of sedition. And if you feel you want to do justice, tender your resignation and move away from this court. So that is the kind of conviction that they had. In fact, if you were to look into the whole construct of this law of sedition is concerned during the freedom struggle, there is not a single leader of India who has not faced this challenge. He has faced sedition charges, and it has sent a number of people for years, decades into prison, whether it is Andamans, whether it is Naini jail, any of that for that matter. This was a very common phenomenon. In fact, it was one of the most hated provision. We said that it takes away the freedom of expression. It does not allow our space, our speech, our articulation regarding what we feel about this present dispensation at that point of time. So when we got the independence, one of the biggest challenges was that how can a law like sedition survive? Because it was anathema to the very construct of freedom of expression. It did not survive in the right of freedom of expression that is guaranteed to citizen under Article 19(1)(a) of the Constitution of India. So the day we got the Constitution of India promulgated as on the date of 26 January 1950, sedition had become redundant. It had no space. That it did nothing to it did not exist. It could not have existed in the law books. In fact, that was one of the biggest challenges that we had. But what happened at that particular point of time is also historical significance, with the kind of Hindu Mahasabha at one level, Communist parties at the other level. The section survived despite the fact that it was opposed to the very construct of freedom of expression. It survived on the ground that Article 19 Clause 2 that came into existence thereafter, saying that freedom of expression was qualified and it was not absolute in India. In the absence of freedom of expression being absolute, and in the existence of restriction of freedom of expression under Article 19 Clause 2, that section 124A survived. In fact, its question was, its existence was questioned in series of judgments thereafter. So the matter was taken up for the first time of the constitutional validity of the same in the serious level at the Supreme Court in the case of the Kedarnath versus state of Bihar. That changed the whole nature. In fact, that was a case where for the first time in that litigation of Kedarnath, the constitutional validity was challenged in the Supreme Court. So when that was challenged in the Supreme Court, after fair hearing, wanted to give space with the given situation that one had to read section 124A, and said that a reading of the section 124A would make it that it is constitutionally valid given how it is understood. So the judgment of Kedarnath was that there are two parts of section 124A. The first part talks in terms of disaffection against the state and the government established by the law, and disapprobation, which is an exception under the subsection 2 of the explanation to section 124A, very clearly demonstrates that the disapprobation is not disaffection. So in fact, way back in Bangobashi judgment, the definition was called, what exactly is disaffection? It is not defined under Indian Penal Code. The judges said want of affection is the only answer in respect of definition of disaffection is concerned. Absence of affection to the state or the government established by law. I think that changed the whole construct relating to sedition is concerned. In fact, it was made very clear in Kedarnath case that not all criticism of the government can be sedition. It's only where when there is promotion of disaffection as against the government established by law, then it tantamounts to sedition. Anything other than that would be not sedition. In fact, it states as defined under section 124A, explanation to it, clearly that disapprobation in any manner whatsoever would not be sedition. Disapprobation is that I don't accept the policies of the government, I am opposed to the policies of the government, I am opposed to the decisions of the government, I am opposed to the kind of acts that are done by the government or aspects which are falling within the ambit of the protection of freedom of expression under Article 19(1)(a). So therefore it said that section 124A protects that. So therefore disapprobation per se is not an offence and it cannot be sedition as such is concerned. So that's something which was clear. But when you look into the history of the sedition is concerned, even after the case of Kedarnath, successive government, irrespective of the fact whether it was Congress government or any other government, this law was abused. This law is being abused even as on this day. In fact, today I am talking about this because of the number of cases that are being registered in India post the CIA and also a couple of years time which we have in Bhima, whether it's Bhima Koregaon case, any of these cases which you look at, that the state is coming heavily using this particular law is concerned. Now the interesting part is that the sedition law now is being applied to even inconsequential cases, like the case of Bidar. All that was said in the play was that my chappal se maar, that I'll slap him with my footwear. Whether that amounts to sedition. If a statement which can be at best said that an abusive statement can be an abuse, disapprobation, an abuse which is saying that I don't accept this kind of thing, which is that I'm not open to kind of acceding to the demand of the government, whether that amounts to sedition. I think that was too far-fetched a case. I think this is something which is getting into the situation. For example, you look at the case of the Mysore, Nalini Balkumar's case, where all that she did was she held a post saying that free Kashmir. What that signify? So even without looking into what exactly it means, the kind of resistance, the police have a situation wherein that registering cases under sedition. Are they doing at the behest of the present dispensation or the political bosses? Or is it because of the knee-jerk reaction? Or is it because of the kind of protests that are happening that the police are scared and therefore they wanted to see that they want to stop some way? I think many of these things need to be answered in coming times. But what matters most is that today this law is being used, which is against the very principles that construct of sedition as has been defined by the Supreme Court right from Kedarnath case. Whether it is Balwant Singh's case, for example, today we have this present day discussions happening, this Amulya Garlamuya's statement. In Balwant Singh's case, the Supreme Court very clearly held that shouting slogans in favor of Khalistan did not amount to sedition. Now, where are we in respect to the same? How can this law be used? I think there is a requirement that the government should look into, and there is a requirement that the courts also should take this into study and call for the action that how the law can be employed, especially more particularly law of sedition, which has been settled by the Supreme Court already, by the full bench judgment of the Supreme Court, constitutional bench judgment of the Supreme Court, and there are so many judgments have come for us in this aspect, which very clearly demonstrate that disaffection and disapprobation are two different constructs, and what exactly is disaffection is very clearly defined, what exactly is disapprobation is very clearly defined. All those aspects which fall within the ambit of definition of disapprobation cannot at any time be employed to mean that they are that the person has committed an offence of sedition. I think it's time that we have a relook at this. In fact, very interesting part is that we need to go back to the way Bal Gangadhar Tilak's case, whether it is the case of Mahatma Gandhi or many of these cases that we have gone through. I think we need to have a require that post 1960, the Kedarnath was delivered in 1962. Maybe at that point of time it was necessity that it survived the consideration. I think as the time has passed now, I think there is a requirement that this law need to go off the record. Good number of countries which had sedition as the law have pulled it off from the law books. There is no sedition is no more an offence; it is an actionable claim at best. And today we have the law. In fact, when we say that we don't have the sufficient security in respect of statements of this nature in the law, I see one possibility that the Indian Penal Code is so robust, and any statements which are made, any aspects that are made, there is sufficient provisions to tackle this kind of situation. There is no requirement for sedition, because sedition as a law is very, in fact, if you look at the way the punishment is in respect of sedition, it starts with the minimum is fine or 3 years or 5 years or life imprisonment. So right from fine to life imprisonment, how is that spectrum of the punishment? How are we going to employ that? What exactly is the cognizance part of it? What is the nature of cognizance part of it? How this trial need to happen in respect to the same? I think it calls for lots of questioning. I think the very nature of the definition which was there in sedition, it was meant for colonial purposes. I think it has served its purpose now. It does not require to exist in the law books. It need to go. Sedition as an offence need to go. It has no place in law to sustain, more particularly with the kind of development that has happened. So for example, take one example which will go is that we have travelled in establishing our democratic credentials across the globe, that we are one of the democratic countries in the world which have survived in last 7 decades and have established and proved the same. So when such is the case, I don't think sedition should survive.